Hi, Kate here from the Safeguarding Academy and welcome to this week's 5-minute masterclass. This week we're talking about the schedule of expectations which is drawn up between parents and the local authority, and particularly how that relates to pre-proceedings meetings, what it is, what its purpose is, and how it then is used in court proceedings. So the first thing to note about a schedule of expectations is it's a bit like Ronseal. That's exactly what it is. It is a list of expectations that a local authority has that a parent will comply with. And the types of things that can be included in a schedule of expectations are really rather wide and varied. They can range from everything from turning up at appointments on time or turning up at appointments, engaging with particular services such as drug services or counselling services, through to engaging with other professionals, perhaps those such as health, GPs, maybe making sure that children attend school on time, are in the correct clothing, and also making sure that parents are available for home visits, either for scheduled meetings or unplanned meetings, because social workers will pop in to make sure things are okay on an unplanned basis as well as on a planned basis. The schedule of expectations will also set out what a local authority is going to do. So it will include things like if there's to be nursery provision, then it will say the local authority will provide nursery for the child at particular times and will set those out. It will also set out whether there's any work the local authority intends to do. So things like arranging up meetings, whether they are going to get in touch with various services, or they're going to provide further information to a parent or carer about particular steps that a parent has to take. For example, where they can go to get domestic abuse support, or where they can go to get drug rehabilitation assistance. And the purpose of the schedule of expectations is very simple. It is a document then which sets out everything that has to be done within a particular time frame, and it makes it very, very clear for both the local authority and particularly the parent what is expected of them, what they need to do to prevent a local authority from taking further action in relation to their children. If they comply with the schedule of expectations, if they are working with professionals and they're taking all the right steps in the right direction, then that can be enough to prevent a local authority taking further steps to start court proceedings and potentially look at removing children from a parent's care. If a parent does not comply with the schedule of expectations, so they're not doing what is expected of them, they're not doing the work that they need to do, then the local authority can use the schedule of expectations as evidence to say this was set out very clearly to the parent, this is what they needed to do, and they haven't done it. And on the basis that they haven't done it, the children are still at risk of significant harm, and therefore, court, we want an order. Now, I'm being very simple with that, but in general terms, that is the next step a local authority will look to take. The role you can have in that schedule of expectations, it can be quite significant. So if you are part of an organisation that is on the edge of that, so you are maybe a nursery provision, you're maybe assisting in terms of mental health assessments, or you're part of the health team, or maybe you're part of the drug rehabilitation service, whatever it is, perhaps housing, you have to keep in dialogue, keep in conversation with the local authority so they know that a parent is doing what they need to do. They know that if a parent isn't turning up on time, they're getting that information in a timely fashion and they're not having to wait days for that information to come through. It's being fed back in a very consistent manner, and it's being fed back quickly so a local authority can take the steps it needs. And that means that a local authority can act much quicker in relation to whether it has to progress matters to court proceedings or whether it can then start to pull back from the high level of intervention in order to safeguard the children. That's all for this week. Thank you very much for watching. If you have any questions, feel free to send me an email. Alternatively, take a look at the blog on the Safeguarding Academy website, which is thesafeguardingacademy.com, and I look forward to seeing you next week.